At the Global South Network, we are deeply committed to promoting interdisciplinary and cross-regional conversation. Our mission has always been to create an inclusive platform where judges, academics, lawyers, and civil society actors from across the Global South and beyond can exchange ideas, share good practices, and learn. On behalf of the network, I am deeply honored to welcome our distinguished speaker, the Honourable Justice Peter Jamadar, Judge of the Caribbean Court of Justice, Vice President Programming of the Commonwealth Judicial Education Institute, and Chair of the Caribbean Association of Judicial Officers.
After all, what would you do as a colonizer from the global north, conditioned by a systemic othering mindset and driven by economic lust built on commodification, including the commodification of human beings? You came upon a series of lush islands with white sands, beaches that are caressed by warm turquoise blue water. But what did they do? They enjoyed the bliss and exploited the people and land for their own benefit. For locals and for commentators from the global south in the Caribbean, colonized, first of course the indigenous, the first peoples, and then imported forced labor in our region, their experience and reflections are that surf, sand, and sea can be tragic reminders of encounters with inhumane, cruel conquerors. For the first peoples of the Americas and the Caribbean, it is from over the sea and through the surf that these colonizers came in their boat, landed on the Caribbean's pristine sand beaches, turned their turquoise waters, their Caribbean seas red with the blood of so many innocents. However, not only were people and lands and resources colonized and exploited, and the point of today's talk is about fact and colonizations of our legal imagination has also been an enduring legacy of colonial history of Caribbean people. How can Caribbean peoples free ourselves from this mental slavery that has captured our legal imagination? Have we been developing a truly Caribbean jurisprudence? There can be no social jurisprudence separated from social context. And so social context is critical to this idea of a Caribbean jurisprudence.
Initiative.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provides a platform for meaningful dialogue and collaboration, fostering efforts to build a more equitable and resilient legal landscape.
GSN Network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is, I believe, the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
كانت جزء لا يتجزأ من الدولة العثمانية.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Quiero expresar mi sincero agradecimiento al Dr. Naumen Riad.
Dr. Naumen Riad, the founder and convener of the Global South Network. His visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas. Initiatives like today's dialogue allow us to compare jurisprudence, share best practices, and develop common principles. This has the potential to contribute to transnational standards in procedure and enhance administrative law globally.
I would like to point out that Dr. Rayat's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism.
We can rule when we want in the cases which are brought to us by citizens and residents. In the EU, this openness of mind is increased by the fact we apply, in some cases, same norms from the EU treaties or the EU directives or regulations.
First of all, the CCJ takes the approach that its core work is the hearing and determination of matters brought before the court, both in the original jurisdiction and in the appellate jurisdiction. And so its first strategy, if you want to call it that, for gaining public trust and confidence is the integrity, robustness, and transparency of its jurisprudence. And so, for better or for worse, and time alone will judge that, the CCJ's first priority is in the integrity, relevance, and relevance of its jurisprudence for Caribbean people. And that is something which a court can't judge for itself. People like yourself and others have to determine whether the jurisprudence is bringing legitimacy to the court. So that's one area. The second, and the question raises this, well, are there other areas? Basically, that's the question. What about judicial outreach, education? Absolutely. The CCJ from inception basically has evolved organs of the court, as it were, some formal, some less formal, which involve themselves regionally to try and develop and improve and contribute to the administration of justice in the region. So, for example, the court in its current strategic plan, which is about to change, has as a particular strategic goal improving regional justice sectors. So that's a strategic goal of the court. It does so in many ways. Formally, there is something called the Academy, the CCJ Academy for Law, run by senior judges of the court, and it intervenes when requested on a project basis by territories and elsewhere to assist in building up the administrative needs and so on. Very recently, the Academy for Law has initiated, coordinated, and completed something called the Needham Point Declaration, which is an overarching approach to trying to reform criminal justice in the whole region, because crime is a big problem in the region, and that has been well received and has been implemented. The court also has supported, I'm chair of the Caribbean Association of Judicial Officers, and that is an organization of judicial officers throughout the region. CCJ provides administrative and staff support for that CAJO, Caribbean Association of Judicial Officers. But the CAJO, for example, has researched and developed many instruments of practical utility. For example, a criminal bench for Guyana, Barbados, and Belize. We are completing, hopefully by the end of the year, another criminal bench book for Bahamas. We've done research into and developed guidelines for judiciaries to deal with persons with disabilities. We've developed approaches to improve procedural fairness, and so on and so on and so on. In fact, together with different international organizations, we've developed, researched and shared reports around dealing with First Peoples, indigenous peoples, tribal groups, and so on, access to justice. So through these, and I'm using two as illustrative, for example, through these two organizations, the Academy for Law and the Caribbean Association of Judicial Officers, the court supports them and they work educationally and in outreach ways to fulfill strategic goal number 6, which is to develop regionally and strengthen regionally the administration of justice and the justice sector, and so on and so on. I could say a lot more about it, but I hope that gives a flavor of how the court responds in ways beyond its jurisprudence to help build, to be relevant, first of all, and therefore, consequentially, to build public trust and confidence in the court. Because yes, you are right, whoever posed the question, 20 years is a short time in the life of institutions such as a regional court.